to IMD Corporate. This program is dedicated to legal solutions for global businesses. I am Adriana Balmas, and our expert solicitors will be here each session to address your legal concerns. I am delighted to be joined by Nicolas Paszek, partner and head of dispute resolution at IMD Corporate. Today's topic has been inspired by the recent implementation of the Fixed Recoverable Costs regime, which came into effect in October 2023. Welcome, Nicolas.
Hi Adriana, thanks for inviting me to speak. Today we're going to talk about the Fixed Recoverable Costs regime, which is a fundamental change to our court system, and it's important that businesses are aware of this change because any business who are caught unaware might lose up to 70% of any contested debt, which is huge.
What used to happen before the change?
We need to understand how the court system operates. When a dispute goes to trial, the court awards two sums. The first sum is the amount of damages, and the second sum is how much of the legal costs are recoverable. For example, if you sue somebody for £100,000 and you're successful, the judge will award £100,000 in damages. But it might have taken you £100,000 in legal costs to get there, and of that, you might expect the judge to award around £80,000. So you always lose an element of your legal costs. The reason judges do this is to incentivize early settlement. If you know before you take a dispute to court that you're going to be writing off 20k of your legal costs, even if you win, you may as well offer to the defendant to accept 20k less than you're seeking, because this will save you 2 years of court hassle, avoid the negative impacts on cash flow of paying your lawyers, and it allows you to focus your attention back on your business sooner. And that's how it used to work prior to the implementation of the Fixed Recoverable Costs regime. You went to court, win or lose, the victor would then get most, but not all, of their legal costs back.
How does it work now?
Since the implementation of Fixed Recoverable Costs, any case where the sum in dispute is greater than £10,000 but less than £100,000 is dealt with under the Fixed Recoverable Costs regime. How this works is that every case is divided into one of 4 bands of complexity. The more complex the case is, the more legal costs are recoverable, and the further you get through the court process, the more legal costs are recoverable. So in effect, there's a table, and at the end of the dispute, you go down the bands of complexity, and then you go across by how long you spent doing the process, and that will give you the figure of the legal costs you can recover. And that's superficially attractive because it lets people have certainty early on as to the amount of legal costs they might expect to recover. However, there's a sting in the tail. The numbers you get under the Fixed Recoverable Costs regime are considerably lower than the numbers you previously would have recovered under the old regime, which still applies to claims over £100,000.
What does that mean for the client?
The best way to look at this is with examples. And we'll use the same base facts for each of the examples. And for easy numbers, we'll use the numbers we've already used, which is a claimant looking for £100,000 in damages and incurring £100,000 in legal costs. And if we start off with the old regime, and the regime that still applies to cases over £100,000, if you won your case, you would expect irrecoverable legal costs of 20k. So that means after you pay your legal costs, of your original 100k debt, you would walk away with a net of 80k return. Under the Fixed Recoverable Costs regime, on the same facts, and assuming you're on the simplest band of complexity, your irrecoverable legal costs are £73,000. So after paying your legal costs of that original £100,000 sum, you would only walk away with £27,000, which is a huge deficit. And that would have a serious impact on a large number of businesses. And even on the most complex band under Fixed Recoverable Costs, you would have irrecoverable legal costs of £39,000. So after paying your legal costs, you'd walk away with only 61k of that 100k debt. So to recap, under the old regime, if you had 100k debt and you won, you'd get 80k back. On the Fixed Recoverable Costs regime, if you have a simple case, you only get 27k of your 100k back, and on the most complex case, you'd only get 61k of your 100k back. And if you're a claimant in the case, and it's caught by fixed recoverable costs, it's certain that the defendant is going to try to persuade the judge that the case is really simple, because that will put pressure on you to settle. And because the change only came into force last October, judges are still finding their way with which band to allocate cases to. And you may also be thinking that if your case is allocated to the lowest band of complexity, that your legal costs will reduce. But unfortunately, that's not the case. And even if a band or the simplest band is allocated, it doesn't mean that the amount of legal work needed to get to trial significantly reduces. So bearing all of that in mind, you can see why this is a very pressing matter for businesses to address to avoid being caught under this regime where possible. And there are a number of ways to do this. When these changes first came out and the numbers were produced, there was a lot of consternation amongst the legal profession and a number of trade bodies. And after some lobbying, it was confirmed that businesses will be able to contract out of the fixed recoverable cost regime.
What is it the clients can do to best protect themselves?
That's a really good question. It has been confirmed that it's possible to contract out of the fixed recoverable cost regime. And where you would expect to see this is in your terms and conditions towards the bottom in the jurisdiction and choice of law section. Now, hopefully, everybody watching this has some terms and conditions that are appropriate for their business and haven't simply been cut and pasted from the internet. And so to incorporate this change into your terms and conditions, what you would need to do is speak to an appropriate solicitor who would draft effective wording for you, but as importantly, advise you as to whether or not you should be cutting the regime out. And that advice is important because although I've described this regime in quite negative terms, and honestly, it is very negative for most businesses, it's only for most businesses. For example, if the dispute was because you'd supplied goods and services to somebody who hadn't paid, it's more likely that you'd want to exclude the regime because you would be pursuing them for payment. But if the shoe was on the other foot and you'd received some goods and services that you weren't going to pay for because they were defective, and thus you were going to be the defendant, you might want to have the case dealt with under the fixed recoverable cost regime, because that would allow you to leverage your argument to put pressure on them to settle, because they're going to have huge irrecoverable legal costs. So it is going to vary case by case and business by business as to whether you should be excluding this fixed recoverable cost regime.
How should people contact us if they want help on this issue?
If people are looking for advice or a change to their terms and conditions to take out fixed recoverable costs, the best people to speak to at IMD would either be myself, Nick Paszek, the head of dispute resolution, or my colleague Alex Kirichenko, who's the head of the corporate department at IMD. And our contact details are on our website.
Thank you to Nicolas Paszek for accepting our invitation to this discussion. We have talked about the recent implementation of the fixed recoverable costs regime. To our audience, thank you for joining us, and don't forget to follow our social media channels and visit our website for the latest insights on our corporate department. Thank you.